Gonzalez versus ONG Industries, and the second one is Metropolitan versus Department of Energy. Has counsel read the notice concerning our virtual hearings?
Yes, Your Honor.
Yes, Your Honor.
Thank you very much. Each side will have 30 minutes to argue. The appellant may reserve any portion of that time for rebuttal. I'm getting some feedback. Where was I? For rebuttal. Counsel, for the appellant, if you will identify yourself for the record and let me know how much time you wish for rebuttal. Justice McDonald will be our timekeeper. I am not seeing his video stream though.
Can counsel see me?
Yes.
There it is. Okay. So how we've been doing this, you may have been to oral arguments before, but the justice or judge that has a question will raise their hand. Once you see that happen, please stop your argument, and then I'll call on that person to ask the question. You also may see a little virtual hand thing that may come up too. Ready to proceed?
Yes, Your Honor. Thank you. James Healy from Cowdery and Murphy in Hartford on behalf of plaintiffs. I'm joined by the remote channel by Joel Faxon in New Haven, the trial counsel, and I'd like, if I could, Your Honor, to reserve 5 minutes for rebuttal, please.
Thank you very much, counsel. Good morning, Mr. Saxon.
And I hope everyone can hear me okay? Okay.
Yes,
all
sir.
right. May it please the court, reversal is required in this case for 2 reasons. First, summary judgment was inappropriate because a detailed factual record, viewed in the light most favorable to the plaintiffs, establishes at least a factual issue as to the defendant's negligence and control in connection with the deadly gas blows. And second, the activity here involved shooting natural gas at high speeds through recently constructed pipes in order to clear debris. That process, which is now illegal, is a classic example of abnormally dangerous activity for which strict liability should apply. I'd like to begin, if I can, on the summary judgment point.
Justice Daria.
Before you do that, Mr. Healy, I think it's easier for me to interrupt you here about this. I just want to understand the scope of the strict liability hearing and maybe how it affects the negligence summary judgment. I'm not that familiar with how you all did this. The judge held essentially a mini trial and made findings. And so I guess my questions are 2. If you had prevailed on that, what would have happened to the case? How would it have proceeded? Would it go to the jury in some fashion? And would control and the like still be part of that analysis? And I guess also then sort of, and I'm going to ask the other lawyers, you've got positions on the standard of review, but how does it really work based upon factual findings on experts and the like on this type of a unique situation? I'm sorry if that kind of derails you, but it does inform how the case got managed. I just don't really understand that.
Sure, Your Honor. And the abnormally dangerous activity hearing took place, I think, in 2015. So it was some time ago now. But my understanding of, I think to answer Your Honor's first question, as a legal matter, I think technically the negligence point and the abnormally dangerous activity point are 2 separate counts. They are alternative theories of liability. As a practical matter, I imagine if this is recognized as an abnormally dangerous activity, that would essentially swallow the negligence portion of the case as kind of a practical matter. But I guess as a legal matter, they are 2 separate counts, and I'm not sure if that answers Your Honor's question. But I think. And
then so how would it have proceeded? This is all I'm going to ask, and maybe I'll come back to it. But how would it have proceeded to judgment if you had prevailed? Would essentially there be a directed judgment of some sort on strict liability, or would there be a jury question remaining?
You're on mute.
You're muted.
You're muted.
Okay. Sorry about that. I guess you could conceive of a theoretical jury question if there was some claim that someone didn't carry on the abnormally dangerous activity. I think in light of the record here, that wouldn't have gone very far. And I'd imagine there would still need to be an allocation of damages and the like from there, Your Honor. So it presumably would have been a different trial and maybe a more focused trial. I don't know if you want me to answer your question about the standard of review, or I know there's another question pending.
Yeah,
as well.
we'll get into it at some point, but everybody agreed to this process, and so there's nobody that would have been demanding a jury find the ultra hazardous facts that underpin the determination.
I believe, just in full candor to the court, that the plaintiff at the time had been of the mind that the full run, for lack of a better way of putting it, of the abnormally dangerous activity facts should have been found by a jury. I read Green, the appellate court's decision, as saying that the determination is one of law. And that's why I guess a short answer to your standard of review question is I think this court exercises plenary review over whether the evidence below, whether it satisfies those factors. And I take the court's point that perhaps it can't judge credibility determinations or the like, but I read the trial court's decision on strict liability really as more of a legal determination. I think the number of facts in dispute are relatively narrow in that light. So I don't think as a practical matter it'll be an obstacle.
I got it. Thanks.
Justice McDonald?
Thank you. Counsel, you said that that the gas blows are now illegal. Is that just in Connecticut or is that nationwide?
I know for a fact it is illegal in Connecticut. That happened, I believe, in 2011. There's some evidence in the record below during the ultra hazardous activity hearing that to the effect that it was illegal in California, some provinces in Canada, and other jurisdictions.
But it was a legal activity in Connecticut at the time of this accident, correct?
It was a legal activity at that time. To that point, Your Honor, it was made illegal because of what the legislature said at the time, the inherent risk involved. And
as a result of this case.
I'm sorry, Your Honor?
As a result of this case, this explosion.
Well, the legislative record, and we put it in our appendix, is, as I read it, as acknowledging the inherent danger that had existed prior to the gas blows that were conducted in 2010. Sort of the unanimous view of safety experts. So my position would be,
it almost seems like it would fall into the doctrine and negligence that you don't penalize somebody for changing something after the fact and apply it retroactively if it was a remedial measure is not used against the person who remediates it, is it?
Well, for one, these defendants didn't remediate, but taking Your Honor's point, I think as I read the legislative record, Your Honor, it's an indication that these activities have an inherent danger to them, and that inherent danger and the Consumer Safety Board's recommendation and those other safety recommendations recognize the inquiry that this court is to answer, which is this an activity that carries a danger that just standard precautions can't cure? And so I think for that reason, the other point I would say about the legislature's act is the legislature didn't say you can do a gas blow if you clear the site of non-essential personnel, or you can do a gas blow if you build a vent stack a certain height. In other words, they didn't regulate a gas blow, they outlawed it squarely. And I think that bears on the strict liability finding as well.
It may, but if it was so inherently dangerous, why wasn't that illegal before this?
And the indication in the record below during the abnormally dangerous activity hearing was that there had been an industry recognition of that danger and that had been recognized prior to when these gas blows were conducted in 2010. One of the defendant's witnesses acknowledged there was some evidence in the record that there had been explosions at other power plant construction sites in the years just prior to this one. And even one of the defendant's witnesses acknowledged that one of those explosions was very, very similar to the tragedy that happened at Clean Energy.
Thank you.
Justice Mullins?
Good morning. On that sort of same tangent, there were two cases. I think the trial court pointed out that these gas blows across the country had been, if not common, they were used a number of times, and there was only 2 cases pointed out where there were problems. And in those cases, there were specific things that went wrong. Why isn't the finding that these gas blows can be conducted as long as the proper safety mechanisms are in place? Why doesn't that pretty strongly undermine your argument?
Well, the reason why, Your Honor, if I may, that's the third liability, the third factor for abnormally dangerous activity is the inability to eliminate the harm. And what the restatement tells us about that is you're looking not at whether the utmost care or all conceivable measures can eliminate the harm, but really it's more focused on the difficulty in eliminating the harm. And the defense witness, the only defense witness who had conducted a gas blow was a gentleman named James Crown. And even if we give him all of the credibility determinations that that one may want to give him, he acknowledged that the steps he would take to conduct a gas blow happened at smaller plants. As he said, they were not anything like the clean energy plant, and he couldn't say they were accepted within the industry. But even taking that at face value, he testified to very painstaking steps you had to take in order to do this without injuring somebody. And that was everything from careful pre-treatment of pipes to building an exhaust higher than anything else, precise control of the amount, the velocity of the gas, precise calculations about the pipes, strict procedures, nobody else on site. My point, Your Honor, these are exacting steps that go well beyond due care, and they go well beyond standard precautions. And
you'll certainly remember the record much better than I do. But I thought even there were experts on both sides that said that this could be conducted if the proper safety mechanisms are in place. If it's not, I guess this one was pointed horizontally. If it's vertical, if it's far enough away from the top of the buildings, I thought that there was this triangle that had to be in place, and if you did those things to protect that, the gas blow should be okay.
So I guess 2 things, Your Honor. The first point, I think to the latter question, there is agreement even by the defense witnesses that even if you build the vent stack in the vertical direction, that will still lead to the combustible combination of the 5 to 15% air gas mixture that a ignition source can and will ignite. Kimball Clark is the PhD witness, defense witness who acknowledged that you couldn't remove that level of risk. And the other point to Your Honor's question about if these steps are taken, the point that we see, and we see it from Mr. Crown's testimony where he lays out, a dozen or more steps that are very detailed and similar, sort of minute precautions that you have to take. And what the restatement tells us is a lot of activities, if you take every conceivable measure, you can do them safely, but that doesn't mean they're not abnormally dangerous. And I'd submit that similarly minute precautions can and do allow for the safe deployment of dynamite, the safe conduct of chemical research, things that Connecticut courts have acknowledged are abnormally dangerous and subject to strict liability. And in fact, it's that inherent danger that requires that detailed level of care and steps in the first place.
Thank you. I think the chief has a question, so I appreciate your answer.
Thank you, Your Honor.
Actually, you and Justice Mullins just covered it. I want to go back just for a second. For some reason, I mispronounced Mr. Faxon's name. He's appeared before me a million times, and I have no idea why I did that. So I apologize to him. But please continue.
I can assure you he will not take it personally. Since we're on the strict liability point, I just want to emphasize the 3 factors. There are 6 factors. We had 1 on 3 of them below, and you don't need to satisfy all 6 in order to meet abnormally dangerous activity. The 3 I had wanted to talk about with this court included the risk, the difficulty in eliminating the harm that we've talked about here. The other and related inquiry is the first factor that involves the risk of harm, the high degree of risk of harm. And that inquiry looks to whether the potential harm is sufficiently great, even if there's only a slight chance that it may happen. And the restatement examples along those lines include the storage of explosives. By contrast, we have the use of a volatile and explosive substance here. The other restatement examples being blasting and dynamite, things that are right in line with the type of combustion that we're talking about here. And we included section 520 of the restatement in our appendix. It's at page 550 in the blue appendix. And I did that because when you read through those examples and you see the commentary, the common thread that jumps out is that things like explosives, gas-fueled activity, combustibles. Those are all the classic examples of abnormally dangerous activity. And I'd submit that we are an extreme version of that type of conduct. You're blowing natural gas at the speed of sound, and you're doing that through recently constructed pipes for the express purpose of clearing debris that can and will become an ignition source. I'd say that's at least as dangerous as blasting, chemical research, pile driving, the types of things our courts have found to be abnormally dangerous. I would like to point out too, there are safer alternative methods that do eliminate the risk involved in a gas blow. You can blow pipes with air. You can blow them with nitrogen or water pressure. Those are inert substances. They will not explode. There's no dispute about that. That's a law of science. In fact, GE recommends air blows, and there had been an energy provider that recommended using air as a much safer alternative to what it referred to as a tremendous safety hazard. And that was prior to the gas blows being conducted on this site. The only other factor we didn't prevail on below, and I'll touch on it briefly and then turn to the summary judgment portion, if that's okay. Gas blows are thoroughly inappropriate for Middletown. The undisputed evidence below is that there's almost 3,000 people in the predominantly residential area within a mile of these gas blows. That included not just houses, but hospitals, and even more than 70 houses, even within just a half a mile. I'm sorry, I see there's a question.
Thank you, counsel. Justice Storia.
Yeah, I saw that argument about Middletown. What difference does that make to you? I mean, your clients were on the site. So, I mean, I can imagine, I guess there'd be some cases where that would be inform the inherently dangerous part of it, but what difference does it make in this case?
I don't think it alters the inquiry, and it notably, Your Honor, if this court finds that 5 of the 6 are satisfied, and this one it doesn't need to reach, I think that's not an obstacle to finding this to be abnormally dangerous. I think the other example that may be helpful on that point is the appellate court's decision in Green, where it looked to the site involved. That was, they were doing chemical research in a Simsbury location, Ensign Bickford, that had been there for 150 years, and apparently conducted chemical research in a building that was surrounded on each side by either heavy woods or a 20-foot earthen berm, and that was.
But the plaintiff in that case needed that factor because he was down the street in bed or something.
Right. And I guess to the extent there's a property damage claimed or something like that, that would similarly apply here, and I think wouldn't be an obstacle to the court reaching that issue. And I'll note too, just before I move on to the summary judgment point, Clean, we put in our reply appendix, pages 46 to 47. Before federal court, there was an acknowledgement from Clean that this is an abnormally dangerous activity. So I'll leave that to this court's determination there. I did, if there are no other questions on the abnormally dangerous activity point, I did just want to touch on the summary judgment point before my time expires. What we have here, it's again, pages 2 to 3 of our reply. What I tried to do was detail a number of facts and some very basic inferences that could be drawn from those documents, from the testimony and affidavits in support there. And that evidence demonstrates not only negligence, but a right of control and the actual exercise of that control. We have defendants who were denominated a gatekeeper of all Clean-related activity on site. That was a broad and inclusive grant of authority in the construction process, and that was how it worked in practice. PPMS was Clean's face on site. The subcontractors acknowledged they had to go through Gordon Holt, go through the gatekeeper to get Clean's approval, and that PPMS spoke for Clean, including in connection with the gas blows. And I see there's a question.
Yeah, I'll just jump in. Yeah. So on that point, I mean, PPMS is effectively just a owner's representative, correct?
An agent, yes.
And so I mean, they're not charged with any of the responsibilities of for the construction of the facility. That was all on O&G, right?
I disagree. PPMS's contract obligated it to do not only construction walkdowns and give assessments back to Clean, but to audit O&G's key processes, including for safety and quality. So I think that's shows the opposite, Your Honor, as a matter of contract.
That's not control. I mean, an owner's representative in a construction deal is to make sure that the owner is getting what they're paying for from the contractor.
That may, and even if that were the case in theory, Your Honor, I think we have to look at the facts as they actually happened here as well. We see Clean Energy telling its gatekeeper to stay in the shorts of the subcontractor. In other words, control, I think, is the entire point of the arrangement. And we see there, too, there had been slippage that left construction behind schedule. The defendants knew there was a rushed job to finish, and that required, among other things, this gatekeeper to stay in his trailer and not ask any questions. I think the obvious inference, certainly a fair inference to draw from that, is that this gatekeeper had enough actual involvement, actual influence, that his presence, his question asking is not simply monitoring or taking notes, but would affect the pace of the work. That's more than the eyes and ears that I think Your Honor has in mind about a construction manager. Another good example of that is the defendants, PPMS included, exercising sole control over procuring the gas, so much so that they changed the amount of gas that O&G requested. That's borne out, the exhibit starts at page 396 in our appendix, where O&G asked for 5 decatherms of natural gas. And I've learned in this process that a decatherm is about 1,000 cubic feet of vaporous natural gas. And this isn't, we're not talking about a math error. The defendants have a substantive disagreement with O&G about how much gas is needed. The documents show they discuss it internally, they go back to O&G and they push back, but O&G doesn't roll over. They say, no, our pipes are really clean. And then ultimately it's the defendants who countermand that and order 200 decatherms of gas. So that's a big change, and that's going to the heart of the method that's used to conduct the gas flow. We also have evidence that the defendants are, the defendants act like they're the ones in charge in terms of subcontractor requests to deviate from the existing methods. Thank you, Your Honor. I see 5 minutes. A good example of that at Clean's appendix, pages 520 to 21, where a subcontractor doesn't just say, hey, defendants, we're doing X instead of Y. They make a request to the gatekeeper, and he responds like somebody who's in charge and has substantive control, saying, I will need drawings of that in order to support your request. And then the subcontractors respond and scramble like the defendants are the ones in charge. Saying, looking to, and I quote, support this request as soon as possible. So I'd submit that someone's role who's approving or denying method changes, that's another indicator of control. We have defendants controlling access to the site during the gas flows. Someone comes to the gatekeeper to ask permission to go to the gas flows. They didn't go to O&G, and the gatekeeper is the one who grants them that permission. In fact, the evidence is he says, be my guest, no smoking. And then the gatekeeper himself is able to access the restricted safety zone during those gas flows. So much so that he's standing alongside employees of subcontractors for the companies that are conducting the gas flows during that first round. So I'd submit that mere eyes and ears can't be granting access to the site to others, and mere eyes and ears can't be doing that themselves.
Justice Kahn?
Counsel, a quick question to that issue. In looking at both the trial court's decision on the summary judgment, but also your argument, there was this issue of there were welders on the premises the morning of the Super Bowl when this happened, and they had a ton of workers there because they're trying to meet this timeline. Who actually brought the welders in? And was there permission? Did permission have to be given to have welders there with, open flames?
So my understanding, Your Honor, of the record is that the welders and the other construction workers, the 2 plaintiffs in this case, were in fact scaffolding workers that those were ongoing construction activities that the Clean representative represented, thank you, Justice McDonald, represented that they would be cleared of non-essential personnel like these plaintiffs and would be cleared of those ignition sources, but in fact they weren't. And I think
Clean controlled that? I'm just trying to figure out who controlled those workers. Was it O&G or was it, were they O&G subcontractors that Clean who controlled that when they could be on site?
Yes, Your Honor, I think I understand the question. And I think there's proof here that the defendants did control that. And we see that from Carl Baker's testimony, the state scientist who, by the way, was a very credible witness. I was in the room for his deposition. He testified that he reached out to Clean, asked to have a Clean representative call him, and that Robert Haley, the gentleman with the Clean business card and Clean email address, called him back and rebuffed his warning about using air or nitrogen instead. Mr. Baker's testimony is they had all kinds of conversations about controlling the number of people, about controlling the ignition sources, and that Mr. Haley spoke of this as a collective effort, that we did it that way last time, it worked out last time, this is how it's done in the power plant business, made commitments that those, in fact, would be done, that non-essential personnel would not be there, that ignition sources would be cleared. And I think that's indicative, again, of negligence and control, that gentleman never claimed to be a simple observer. The fair inference from Mr. Baker's testimony is that he made representations and acted like somebody who had control and who could have an effect on these things. And Mr. Haley, asked in his deposition, he didn't remember really anything at all. But nonetheless, when he didn't dispute that he may well have had that conversation. And when asked whether, if he'd had that conversation with Mr. Baker, should he have done something about it, he acknowledged that he should have. He didn't say, hey, I was just eyes and ears, I'm just taking notes. I would have told Mr. Baker to call O&G, or I would have told him to call somebody else. So I think that is indicative of who has control there. I will note, too, the gatekeeper himself has a written email, thank you, Justice McDonald, a written letter over his signature on clean energy letterhead, talking about spending, and I quote, a considerable amount of time working closely, end quote, with a gas flow subcontractor. Not observing, not eyes and ears, working closely. So much so that he had, and I'm quoting again, firsthand knowledge of the conditions and failure protocols that led to the gas flow explosion, end quote. And he offers a detailed basis for that, saying that if different methods had been followed, it wouldn't have happened. So that's further proof that these defendants are actively involved and actively involved on a decision-making level. I'm sorry, Your Honor.
Justice McDonald.
As you're winding down your time, let me just ask you, could they have ordered O&G not to do something?
They have the ability.
Responsible to comply with any orders from PPMS?
I'm sorry, Your Honor, is your question about PPMS or Clean ordering O&G, or both, perhaps?
Either.
Yeah, fair question. Clean Energy had the contractual ability under 14.1 of the EPC agreement to stop work at any time on written notice.
You can finish it, but your time is up.
Fair enough. Thank you. And I think that speaks to the right to control. Both of these defendants had a right to control. Clean Energy, including by that provision and by way of the master agreement, where it was obligated to CL&P to build the facility. And that's in fact why they withdrew the force majeure defense in the administrative proceeding. I mean, we're really talking about a defense so weak it was withdrawn before the DPUC. The defendants are now asking for judgment as a matter of law on that basis in light of this record, on summary judgment in civil court. And PPMS, again, had the contractual obligations, certainly at least the right to control that we talked about before, Justice McDonald.
Thank you.
I know that my time is up. I'll reserve any that I may have remaining. Thank you.
Thank you very much. Counsel for the appellee, are you ready to proceed?
Yes, Your Honor. Tom Plotkin of the law firm of Rome McQuiggan for Clean Energy Systems. By letter, we had notified the court that we wanted to allocate the time between the two co-appellees, 20 minutes for me, 10 for my colleague, and if any time's left over, back to us. So I just want to make sure that's clear.
That's granted.
Before I go into my general statement, I just want to address a couple of things that Attorney Healy mentioned. He spoke of how James Crown claimed only to have worked on small plants. He was the expert who had actually performed gas flows. If you read his testimony at our appendix 836 to 841, he speaks of doing gas flows on plants that are large and similar to this one and the same sort of turbine. So I don't think that is wholly accurate. The testimony he invoked concerning our expert Kimball Clark, the forensic fire expert, about the difficulties in calibrating a perfect vent upward. If you look at our appendix at 483 to 486, it was all attached to hypotheticals involving the presence of a target, which was their expert's theory of the case, which was generally discredited. The evidence showed there was not a target on the being used on the vent that was being blown at the time of the explosion. So these testimonies are not really accurately represented. I would say there's a little more going on there than they're not retrenching from their arguments. I'd like to address, because I think it's actually one of the Judge Mukasher in his decision on summary judgment acknowledged it was sort of one of the issues that caught his apologies. Yes, Your Honor.
Thank you, counsel. Justice Khan.
Sorry.
Thank you, Chief. I'm actually was going precisely to where you're going, Judge McCoucher's decision on summary judgment. I'm looking at appendix, the plaintiff's appendix at A239. Judge McCoucher covers some emails from Gordon Hulk of Power Plant Management Services. And the one at the top of page 4 of his decision, the plaintiffs emphasized that you are clear to blow, that the email where he says you're clear to blow, but the plaintiffs ignore that the email isn't about granting permission. It merely announces we have the gas and therefore you're clear to blow. In light of what your opponent said, that it was, there was even a change to the amount of gas that was ordered. How is that email not a question of fact for a jury? In other words, maybe Judge McCoucher saw that as it referring to, hey, we just have the gas you need. But why couldn't a jury looking at that, why couldn't that email be read in more than one way? And why isn't that a question of fact for the jury? You're clear to blow, meaning you have my permission to go forward with this, particularly if they were involved in determining the amount of gas that was going to be used.
First of all, Your Honor, I don't think there's any evidence showing. Clean noted, or PPMS noted, an error in the calculation and brought it up with ONG. And Clean ordered a larger amount of gas subsequently. There is no evidence that Clean Energy came up with that final determination of how much gas should be used. Simply nothing in the record.
But do you deny that as the decision goes on, there's also an email that says, I need to approximate the amount of gas you will need and when? Couldn't that be interpreted that they're determining, that they, meaning Gordon Hawk and Power Plant Management, your client, and Clean, are also determining the amount of gas? I mean, that doesn't sound to me like, hey, just tell me a number, I'll order it, and then I'll tell you when it's here.
That is the very first time, I believe, Gordon Hulk was told of the gas flow plan. It's the earliest on the record. It's sort of the initiation process. And I think I don't see him as making orders, as giving. He was thinking ahead as to what he'd have to do. He's not dictating anything. He had a ministerial duty.
But that's precisely my point, counsel. Doesn't that make, summary judgment, if there's any question of fact, anything that could be read two ways, then shouldn't that go to a jury? Maybe a jury will agree with you that that's how that email should be read. But why shouldn't that go to a jury? That's really fundamentally my question.
I'd like to reference, by way of answering, the sort of the standard for what has to be shown in terms of control in this kind of context from the Archambault case. I believe plaintiffs actually quote this in their own papers. To prove control, the plaintiffs have to show Clean assumed direct control over or interfered with ONG's responsibility to perform its work safely. ONG didn't have to say yes to anything said to them by PPMS or Clean. Anything advisory or would be taken on advice. It's not something they had to do. It was Clean had a.
So I see your point on control, but is it just control? I mean, and your opponents mentioned during his oral argument that at the end of the day, Clean really controls this, right? Clean controls this at the end of the day. So with those provisions and this, these emails and the fact that they're approximating and they can stop the project, why, first of all, why isn't that control? And second, why does it have to be control? Can't it just be involvement in participating in the decision-making?
Your Honor, I would submit it is not mere involvement. It is actual control of the work and control of ONG's movements and methods. I would say, if I may, we submitted to the court a supplemental authority, the restatement 414. If I may be allowed to quote, that's about partial control, which plaintiffs claim. Comment C states that an owner must exercise such control that, quote, the contractor is not entirely free to do the work in his own way. Comment B provides the owner must superintend the entire job for such liability to attach. And if I may be allowed one more before answering Judge Doria and finishing up with you, comment C makes the authors of their statement provided a very helpful list as to what does not constitute partial control, the ordinary perks of ownership. Quote, a general right to order the work to be stopped or resumed, to inspect its progress or receive reports, to make suggestions or recommendations which need not necessarily be followed, or to prescribe alterations or deviations. I submit that's exactly the kind of conduct that the plaintiff is describing in their submissions, and it does not add up to control. I apologize for going over.
No, that's quite all right. And I know Justice Doria has his hand up. Thank you, counsel.
Thank you, Justice Khan. Justice Doria.
Yeah, counsel, please don't rush. We try to get into the queue by putting our hands up, and that's to the chief. So I hope I didn't rush you getting done with Justice Khan. My question, I'm going to be careful not to dazzle you and my colleagues about my knowledge of this process and the chemistry that's involved here. But it's I want to ask you a question about the amount of gas that's ordered, which I understand is tethered to, it affects the speed with which it's going to pass through the pipes. But is it dependent on how much debris is in the pipes? And how do you know? Are you guessing?
For knowing how much gas to order?
How much gas to order, but I'm focused specifically on the debris, which the particles, I guess, if they go too fast, right, that's how things can ignite. Do you know how much debris is in there when you order the gas, or are you guessing?
I have not heard much on that. I know that Mr. Crown, the man who'd actually performed gas blows, said, you pre-clean as much as you can and try to keep the pipes clean during construction. That, of course, is the optimal situation. I don't know if it happened here.
But so I guess that's part of my question. I may be bleeding into the ultra hazardous, but I think it may affect the control as well, as far as who knows, who has the information. But isn't that possibly part of the ultra hazardous? I mean, if the risk is the particles and the debris that are in there, and you don't know how fast you're going to be firing that stuff through, and too much gas, too little gas, you're not going to clean well. Too much gas, you could have an explosion. If the record wasn't developed as to how you know that, then don't we have a really difficult situation on our hands?
I think I have an answer to your question. The standard for gas flows, as mentioned by our experts, by Mr. Clark and Mr. Crown, is the manufacturer of the turbine. Remember, this is all for the benefit of the turbine, so it doesn't get chewed up by debris. Had a specification of 2 times the ordinary amount of pressure gas is sent through the pipes. Twice with it's called the cleaning force ratio. 2 times we'll get it clean. That seems to be a presumption. So I think that dictates sort of the amount of gas used, and I think it's reflective of what is expected to get debris out, presumably vented upward and not at a 45-degree angle into an object. So the CFR, the cleaning force ratio, is the crucial figure and as to determine the amount of gas to order, and it's a manufacturer's specification that Simmons, the maker of the turbine, actually signed off on. And of course, horrendously, it was actually, I think, done at like 5 times that amount during the proceeding, which may have created, I think our expert, Mr. Clark said, converted the kinetic energy of the fragment into thermal energy and sparked the spark. It was another negligent act. They used too much gas too fast, going way above the specifications of the manufacturer. And indeed, that's another argument militating in favor of negligence rather than ultra hazardousness. It could have been avoided. Does that answer your question? Thanks. So if I may circle back, if no one has a question, one of the issues that Judge Mukasher said sort of stopped him short of presented by plaintiffs was the conversation with Mr. Baker. And what I think is really interesting here is the characterization of what that conversation was as a dire warning. A dire warning, which Mr. Haley was supposed to bear back to his employers to say, look, we really can't do this, guys. The Mr. Baker said it's simply too dangerous to do. I have read that deposition testimony in that report over and over again, looking for a warning, and I haven't found it. Indeed, Mr. Baker says something rather interesting. He characterizes the conversation during the deposition. It's at A378 of the appendix, I think in the lower quadrant page of the 4. He's asked to describe by trial counsel, you had a conversation about providing guidance as to proper procedures. That's lifted right from the DPUC report Mr. Baker gave. And Mr. Baker responds, we had a conversations about how we do things in the gas industry. They explained how they do things in the power industry, and they didn't line up. That is pretty much the extent of the conversation. There is no warning there. I've been looking for it for months, and I do not see a warning offered. I hear someone saying, we don't do it this way. What do you do? We do it this way. Okay. You thought about alternatives? No. Here's how we do it in the power industry. And by the way, how it's done in the power industry squares with the expert testimony as to the prevalence of this procedure in the building of power plants. I don't see a warning. I don't see a duty to warn because I don't see a warning. As to the other half of the supposed negligent conduct concerning the conversation with the regulator, the things that Mr. Haley, supposedly Mr. Haley, whoever was speaking to Mr. Baker, specified were items that were within the written protocol that ONG commissioned by Blue Water to write and circulate to all the concerned parties. That was the basis of the one safety meeting they did have for the January 30th blow that went cleanly, that went well, no pun intended, that there'd be no ignition sources present and that there'd be no, there wouldn't be excessive personnel on site. If he were to go back and tell ONG that, they'd be saying, fine, we know that. We wrote it in our gas protocol. Thank you very much. And by the way, Mr. Haley, like Mr. Hulk, had no authority to dictate means or methods or change procedure or anything else. He was the man who was to run the plant's operations after the construction was finished and was merely shadowing construction now. So I don't see this supposed ticking bomb with the regulator conversation as being anything like what it's depicted as in their papers.
Justice McDonald?
Counsel, to that point, I mean, the documents say who is supposed to do what, but as the plaintiff's counsel points out, things might change in the field, and somebody might be asserting himself, I forget some of the names, but asserting himself outside of the bounds of what that proper role would be. Why isn't that a fact question for the jury to make that determination about whether somebody was exceeding their contractual role?
Are we speaking in general terms of the broad array of conduct? I would say I think the Baker example is a very good one. The testimony, it's what they're alleging simply doesn't even on its face, looking in their own terms and their own language, doesn't even add up to that sort of exertion of control, particularly if you keep my definitions of control in mind, that from Archambault and from the restatement that I provided. They don't reach that far. The plaintiffs cited the straw pond case for the notion that if there are conflicting facts, summary judgment is not appropriate. These are not conflicting facts. This is looking at the facts that they presented. They don't add up. They don't bridge the gap. There's an inference which is sort of fact A, an inference part of the inference is fact B. Inference is always composed of two facts, according to Kern versus Kroll, from which one can draw from the other. And in between the two facts is merely invitation to speculate and inject possibilities rather than probabilities in every single instance. Thank you, Your Honor.
Justice McDonald, you have anything further?
No, I'm done. Thank you.
Thank you. Justice Khan?
Thank you, Chief. Counsel, taking you back to the page of the transcript you directed our attention to, you said the testimony was simply indicating that they do it one way, we do it another way, they didn't line up. But the next question immediately after that quote, the question from counsel is, okay, so your guidance provided was to use nitrogen and air to clean the pipes, right? Answer, I suggested that's how we do the work, and we do it safely, and we've never had any issues. We use the same types of turbines in our compressor stations as power plants use, and we've never had a problem with the cleanliness of our gas. So doesn't that actually support your opponent's theory that the recommendation was to use nitrogen? So you got to read what you read to us before in context. And if you read it in context, it's not just, hey, they do it one way, we do it the other. We do it this way because it's safer. And why shouldn't a jury, hear this evidence and determine to what extent your client was involved in making decisions, to what extent your client could control the method that they would use? Because ultimately, at the end of the day, your client is hiring ONG. So why wouldn't they be in control?
Your Honor, there are many things you're putting out there, but the first is that is not a warning. It is to still suggest, we do it this way. It's less combustible. No one's going to deny anyone that that nitrogen is less combustible than natural gas in theory. But it doesn't make it a warning. It's a recommendation. He may be saying, do you sure you guys know what you're doing? We do it this way. The word dire warning does not apply to that conversation in any way, shape, or form.
Well, I get that. Maybe not dire warning, but certainly a warning. And why, the fact that we're having this discussion, doesn't that suggest that ought to be before a jury so they can make that determination?
I don't think so, Your Honor. I think the characterization of this is as a dictate that had to be followed, or as something that was an indicia of the pure lack of safety of what they were about to do. That's not there. That's simply not there. There was nothing to report back. The gentleman from the gas company said, we do it this way, and we think it's better. That's not they probably know the relative safety merits of both. It's not a warning. As to ONG's control, as to Clean Energy's control, simply put, this was a turnkey agreement whereby possession and control of the facility was surrendered. I'm sorry, Justice McDonald.
Thank you, Counsel. Justice McDonald.
Yeah, so let me just, I don't know that this is squarely before us, but I am assuming that there were a lot of workers' comp cases vis-a-vis ONG, right?
Yes, Your Honor.
So if we disagreed with you and this went to trial, and your clients would presumably bring ONG in for apportionment purposes, can that even happen? Given the fact that there was a workers' comp cases, which was the exclusive remedy for those folks?
Your Honor, I have thought of tentatively, I would say that seems likely. Keystone and Blue Water might be the apportion, defendants. There is an indemnification claim, I believe, against ONG, but I don't know if that's either here or there.
That's fine. I didn't mean to. Okay, thank you.
Okay. As to control, just back to the beginning, this was a turnkey agreement. Turnkey agreements are recognized instruments whereby Clean Energy surrendered possession of control of the site and of all the work, and ONG in turn took on responsibility for safety and risk of loss. Simply put, as I've said, and then that possession and control would pass back to Clean upon completion, and for all this, a premium was paid. Clean Energy had no employees. It needed someone to monitor the progress of the contract. That was PPMS's job. The contract it was monitoring had nothing to do with means and methods of construction. PPMS was merely there to see what was going on. Was the contract being executed timely and in the manner it should? Never did they step out of those bounds. The definition of control I provided from Archambault, whereby there has to be true interference and true shoving away, is simply not there. Thank you, Your Honor.
Anything further, Counsel?
Chief, that was the allocation over the 20 minutes for him, and now co-counsel has its 10 minutes.
And sorry, Justice McDonald, my video feed has dropped everyone except for Attorney Plotkin and Justice Daria, so I can't see.
So it's Attorney Scully has his 10 minutes here, Chief.
Thank you.
Thank you, Your Honor. To introduce myself, my name is Bill Scully, and I represent Power Plant Management Services in this matter. With me on a camera shot is another attorney in our office, Lorinda Kuhn. I want to follow up on some questions that were asked, and specifically the questions regarding Mr. Baker. I want to make it very clear to this court that there is absolutely no evidence whatsoever that Mr. Baker ever spoke to anybody from PPMS. There is absolutely no evidence before this court that anything that Mr. Baker may have said to anybody, any purported conversations, was relayed to PPMS. So it's a made-up argument where plaintiff tries to argue that the defendants, lump all the defendants together, when in fact there's no evidence to support that. So anything that occurred in the conversation with Mr. Baker and Mr. Haley is irrelevant to PPMS. I also want to make it very clear that the only contract which PPMS engaged in is the contract it signed with Clean. It didn't hire anybody else. It didn't hire any subcontractors. In fact, under the contract with Clean, and I believe it's section 3.3, PPMS was precluded from hiring any subcontractors. So they didn't hire O&G, they didn't hire Keystone, they didn't hire Blue Water. O&G had care, custody, and control of the plant. PPMS is not experts. They're not in construction. They're not experts in design. They're not experts in gas blows. Mr. Hulk testified to that. He's not an expert in gas blows. The court inquired as to why, about the fuel oil pipes and how it was determined. Oh, I'm sorry, Your Honor, I didn't see your hand raised.
Justice Kahn.
Thank you, Chief. Thank you, Counsel. I understand that you're trying to limit PMS's role in this, but you do concede that they were hired by Clean, right? Your client worked for Clean. Your client had a boss, right?
We were hired by Clean, yes.
So your client had someone they responded to. They didn't just magically appear on the project, did their thing and leave without any interaction or direction from Clean, correct?
Well, Clean doesn't have any employees, so they're sort of a empty shell, and they're an investment.
But Clean hired O&G, right? Clean hired O&G.
That's before PPMS got involved, so I'm assuming so, that the EPC contract is between Clean and O&G.
Okay. Well, your client doesn't just show up on a project and not understand who the players are, who its boss is, and who they respond to. So, you know, they are, in, for maybe lack of a better word, the agent of Clean, correct? Would you agree with that?
We are the owner's representative. If the court wants to classify that as the agent from a construction term, we would be the owner's representative. We're protecting.
So as the owner's representative, whatever your client's employees do, they do on behalf of Clean, correct?
They do under the contract with Clean to protect Clean's asset.
Okay. And they have to, by definition, interact with O&G, no? To do its job?
The interaction with O&G was limited. The interaction was limited to essentially asking questions, not making demands. There is no evidence in the record that they had the power to control O&G. In fact, what the best evidence on that issue is, and it's cited by Judge Sheridan in his decision on the ultra hazardous, is the plaintiff's counsel makes a argument regarding a whiteboard. Gordon Hulk had mentioned in an email that on prior projects he had seen a whiteboard used, and plaintiff's counsel suggests, see, we're dictating the means and methods. But as Judge Sheridan noted, no target was used, therefore no whiteboard was used. So if we had the power to demand or the power to control, apparently O&G didn't believe so. I'd also like to point out that Your Honor, Justice Kahn, made a very poignant comment when you were talking about Mr. Baker's testimony and the letter. and you said you have to read things in context. And that's the crux of this case. And Judge McCausher looked through all of the documents and read them in context. So the amount of gas that was ordered by O&G, PPMS questioned it, they didn't demand it, and as Attorney Plotkin said, there were no changes to that order. So they didn't have the power to control. I'd also point out that under the contract with Clean, there's a provision, 17.8, and we had argued on alternative grounds. We had filed a motion for summary judgment approximately 7 years ago, arguing under the essentially Pelletier 1 and Pelletier 2 analysis that our duty, based upon section 17.8 in the contract, was solely towards Clean, that we had no duty to any other party other than Clean. Judge Sheridan, when he denied that motion, didn't address 17.8. In fact, it's absent from his memorandum of decision. It's absent from the plaintiff's brief. In fact, the plaintiff's reply brief, footnote 7, simply attempts to dismiss the argument, saying somehow the argument's waived, but it's not waived. You can't summarily just dismiss 17.8, which specifically says, thank you, Your Honor, which specifically says that there is no duty to third parties. So as in the Pelletier 1 and 2, we're essentially in the position of professional services from that case. Professional services, as you will recall, had been hired to check wells. A well failed, the plaintiff was injured. The plaintiff sued professional services, and the court on 2 occasions found that the duty owed by professional services was not to the plaintiff, but only to the contracting party. And so they upheld, Your Honors, upheld on 2 occasions summary judgment in favor of professional services. So I'd submit, Your Honor, that GPMS's role related to the gas blow was simply to nominate gas. There's no evidence in the record we didn't fulfill that obligation. In fact, the evidence in the record is we're not even present that day. We're not required to be present nor expected. As far as the issue of control, in footnote 10 of our brief, we point out what the actual boots on the ground thought as far as who was in control. They were asked at their depositions about a responsibility matrix and whether or not PPMS was in control. And each one, O&G, Keystone, and Blue Water, the 3 entities, the boots on the ground, all said, no, PPMS is not in control. And that's right, because we are not gas blow experts. We're simply protecting the asset. We don't build the plant. We don't tell them how to clean the pipes. We don't tell them what medium to order. We didn't have that power. All we did was have the power that's limited by our contract with Clean. And under that contract, we owed no duty whatsoever to anyone else.
Justice Kahn?
Thank you, Chief. So if you have no power, you don't control anyone, you don't do anything, what are you there doing? What is it? You said all we had was the power under our contract. What is that? Can you define what that was? Is it just eyes? You're just looking and reporting? What is it that you're doing then?
Essentially, Your Honor is correct. It's monitoring and reporting. It's walking around the plant, protecting the asset, telling them before they write a check. For example, there was a question that raised the turbine. And if the turbine cost $1 million, before Clean writes that check for $1 million, PPMS goes and says, yep, they got a turbine and it's the right one. They're not making the judgment whether or not it's defective. They're not making the judgment whether or not it's powerful enough. What they're doing is just saying that's what was ordered. That's what they're paying for. So that's what they're doing. They're monitoring and reporting to protect the asset, and the asset is essentially finances.
I mean, forgive my question. Maybe I'm a little bit misunderstanding, but in a prior life, doing a huge investigation involving contractors and structural engineers and multiple contractors, yes, you're working for the owner as the manager of the project. But quite frankly, if you don't manage it well and make sure that the right equipment and the right material is used, you're not going to be hired the next time they do a major contract. So I'm not sure that I necessarily agree that underlying your client's obligation isn't an obligation to make sure that this plant is constructed properly with the right equipment, with the safe equipment, and that it's going to run. Otherwise, what's the point of your company being there? They could manage it themselves. They could hire somebody at a much cheaper rate if it's just check an invoice to make sure what arrived on the plant is the right material.
If I can, my time was up, but I will respond to Your Honor's question. We are not managers. We weren't hired to be managers. We are owners' representatives. The manager, the general manager on the project is O&G. They're the ones that determine whether or not the plant meets the building specification. They're the experts in construction. They determine how to build it. They determine what they need to build it. They determine what workers they need to hire to assist them in building it. They're the ones that engage Keystone. They're the ones that engage Blue Water. Oh, we don't hire anybody. We don't make determinations whether or not the plant is built correctly. We are relying on O&G to fulfill their obligation under the EPC contract to have care, custody, and control, to turn over a turnkey project that meets the design-built standards.
Attorney Scully, there's a question from Justice Mullins.
I may have gone over this. I wanted to ask you, maybe I should have asked your co-counsel, but I thought there was mention in the contract that Clean could stop work at any time, or on written notice could stop work. Is that right?
If you're referring to the contract between PPMS and Clean, we had no ability whatsoever to stop work.
Okay.
The contract between Clean and O&G, I think Attorney Plotkin addressed that in his memo, saying that, and in his brief, talking about what the stop work means. It didn't mean they could walk in and just say, okay, everyone's done. There were specific limitations, and because the issue of stopping work isn't pertinent to the role of PPMS, because we had, under our contract, we had no ability to stop work. If I have any time left, and Attorney Plotkin, if Your Honor is correct, that should be directed more towards Attorney Plotkin.
It's okay. I'll figure it out. Thanks.
Thank you, counsel.
Attorney Healy, the Chief's authorized you to have a couple of extra minutes, so you'll have 7 minutes for your rebuttal.
Thank you very much. I just want to start. If Attorney Scully and Attorney Plotkin, at the end of a trial in this case, want to get up and give a closing argument and ask a jury to talk about what they think the context should be, or what inferences they think should be drawn from evidence, and to disregard something about changing the amount of gas, or to disregard something about granting access to others to attend gas flows, or to disregard the email about their job being on Clean's behalf to stay in the shorts of the subcontractors, about them being so involved in what's happening on the ground that if they don't stay in their trailer and not ask any questions, the rush job to finish won't get completed. That's for a jury to decide. It's for a jury to decide whether Carl Baker, the fact-based, just the facts state scientist, is telling the truth when he's testifying, or Mr. Haley. I'm sorry, I see a question.
Thank you, counsel. Justice McDonald.
Thank you. Counsel, what is don't know how to ask this question. What is the proper role of an owner's representative? I mean, is that a defined industry standard of what role of an owner's representative undertakes?
I don't think there's anything in the record about that, Your Honor. I think perhaps the answer to give to perhaps the concern behind that question, Your Honor, is if you have an owner's representative who is simply in their trailer, as Justice Kahn said, monitoring invoices, making sure things come through, maybe rubber stamping things, but not doing much more than that, then this would be a different conversation. But as we say, and in the evidence we highlight, pages 2 to 3 of the reply, those bullet points there, you're dealing with somebody who's doing much, much more than that on the ground here. Or certainly, we can't say that it would be an unfair inference to make that conclusion that when you are the person who is acting like they're in charge of a subcontractor who's requesting a change to the methods, that's not a subcontractor saying, hey, eyes and ears, just to let you know we're doing X instead of Y, make a note. That's not how this was working. And I think that's the critical difference in why summary judgment's not appropriate.
Well, I haven't yet mastered the contract between Clean and PPMS, but it doesn't seem like you're just supposed to sit in the trailer. You probably have to pop open the hood and see what's actually being done to make sure that all of the infrastructure is being assembled the way it was contracted to be assembled. Don't you agree?
Well, I think, Your Honor, that I guess that's right, but I think the evidence we have in this case goes beyond that. We're talking about somebody who is getting involved in the actual methods. Mr. Plotkin wants to talk about you have to have control over the methods. That's exactly what we're talking about here. How much gas is ordered and why? What types of methods are used to test pipes and to show whether they're clean? Who's to be where and when? Who's to the gas pipeline safety unit. I think that is fairly read as a warning when Carl Baker testifies that he told them Connecticut never cleaned its pipes with natural gas, never, ever. And to say nitrogen is less combustible, nitrogen is inert. If they had followed Mr. Baker's advice, this wouldn't have happened. And I think it's important to note, I know there's a question pending, if Your Honor will permit me. Peltier is a case about off-premises negligence, where a subcontractor did a bad weld on a site that was solely owned and solely operated by a subcontractor. And that defendant had zero supervisory or other involvement in welding. The bad beam was brought to the site. It failed within minutes. And Peltier says, look, you didn't have control over that because it was done off-site, so you're not liable for control. But negligence is separate from control. They say if you know or have reason to know of something going on, you can be liable for your own negligence. And I think this is an eminently foreseeable example in contrast to Peltier. So I don't know if that answers your question, Your Honor. I know there is another question pending as well.
Yeah, and you have 3 minutes.
Thank you.
Thank you, Justice McDonald. Justice Kahn.
Thank you, Chief. Counsel, my question is, in my experience in prior large contract cases, particularly those involving governmental entities where major projects are built, usually a company like PPMS is brought in because of their expertise in the industry, and they can monitor far better than the owner whether something is being constructed according to industry standards. So that, and I have, like Justice McDonald, I too need to study the contract between PPMS and Clean, but I wonder if you know, were there bids out to for that project to see who was best equipped and who had the expertise to properly provide the oversight on behalf of the owner to make sure this is constructed appropriately? Do you know if that occurred, if there was like a bid, and whether PPMS won it because of their expertise in the industry and to be able to rather than just rubber stamp?
I hear you, Your Honor. My understanding is the record doesn't bear on that directly. But PPMS stands for Power Plant Management Service. It's not monitoring or eyes and ears service. I mean, I think it's a fair inference to be drawn, and certainly a fair inference that this jury could draw. The point here, And I think it's important to remember, too, the responsibility matrix that was discussed below, that had PPMS, the gatekeeper here, Gordon Holk, was the responsible individual for gas flows. And if other witnesses may say that they didn't think there was shared control, there's certainly evidence that shows he was. And the responsibility matrix also has Gordon Holk responsible for a host of other construction responsibilities, discharge monitoring, equipment piping installation, fuel oil trucks, the list goes on. The point is, it's further proof, along with the rest of the evidentiary record we've talked about a lot today, that the defendants had detailed involvement in many methods of the construction process here, including in particular the gas flows. I see 1 minute, Your Honor, thank you. The two things I want to mention quickly before my time elapses. There was a reference to Mr. Crown's testimony at page 487 of our appendix. I'm aware of an exchange with counsel where he acknowledges that he was not aware of any gas flows after 2009, which is, by the way, when the industry has an awareness that these things are dangerous, and that those had been at small plants that were not anything like clean energy. So I'll leave that for this court to decide what his testimony is on that point. And the other point we haven't talked about, and I don't hear any objection to the idea that gas flows, even if they aren't abnormally dangerous, at a minimum, qualify as inherently dangerous. Which is something that would require reversal of summary judgment. That's something this court in Peltier 2 and in Peltier 3, in fact, substantively examined a claim of inherently dangerous activity under Section 413 of the restatement with respect to welding. So I think that is a viable claim, and summary judgment would have to go back on that basis alone. I know there are questions.
Justice Mullins.
Did the trial court make a finding on inherently dangerous?
The trial court's decision, that's from Judge McCousher's summary judgment decision, the 2019 memorandum, Your Honor. My understanding, as I read Judge McCousher's decision, I think it's a little bit, I think he was under the impression that, well, if it was vicarious liability, that wasn't allowed here. And I think the best guidance on the inherently dangerous point comes from Peltier 3. This court in Peltier 2 overruled Ray against Schneider, which was the idea that a subcontract employee couldn't make a claim. That's, in fact, the only objection Clean Energy has offered to inherently dangerous at all. They don't dispute that it is inherently dangerous. Peltier 2 stands for the proposition you can bring the claim, and Peltier 3, Your Honor, examines that claim on the merits. The claim there was that welding was inherently dangerous.
Maybe I'm just asking, I appreciate that. I don't recall, but did Judge McCousher make a finding that it was inherently dangerous or a finding that it was not inherently dangerous?
He found that there was, he granted summary judgment in the face of the argument and the claim, Your Honor. So I think it's properly before the court, if that's the question. But Peltier 3 did involve, the claim there was an injured subcontractor employee, like we have here with these plaintiffs, made a claim of inherently dangerous activity. That was with respect to welding. And Peltier 3 said, look, welding is not inherently dangerous. Inherently dangerous under the restatement talks about instrumentalities like fire or high explosives that require constant attention and skillful management to avoid harm to others, which is exactly what, at best, the defendant's witnesses in the abnormally dangerous activity hearing acknowledged, that you can do this without injury, but it takes a lot of painstaking steps. And I know there's another question.
Mr. Healy, I think you just answered it for me. We're throwing around a lot of terms like inherently dangerous, abnormally dangerous, ultra hazardous, and they all have different results under our jurisprudence. But I think you just answered the question I was going to ask, so thank you.
Okay, Your Honor. Thank you.
Anything else, Mr. Healy?
I would be happy to answer that question again, Your Honor, if there was any lingering doubt about ultra hazardous versus abnormally dangerous, which are the same, and inherently dangerous, which is a slightly lower category. But I take it that's been established. Thank you.
It has been. Thank you very much. With that, we'll call this matter to an end. We'll go in recess until 11 o'clock for the next matter. Thank you very much.
Thank you, Your Honor.